Gerald says, is due diligence still a thing for new builds that are completed? Yes, they are. We'll get into that more in a minute. Did I say due diligence goes to the seller directly? It gets deposited in their bank account. Earnest money is held in escrow. You look like you still have a thought, Beverly. You're good. So this is hopefully going to sound familiar because you already explained to me the effective date is the day we actually form a contract. Well, the two criteria that make it the effective date, aka a contract, are the date that one, the last one of the buyer and seller has signed or initialed this offer or the final counteroffer, if any. And two, such signing or initialing is communicated to the party making the offer or the counteroffer as the case may be. This is what I taught you yesterday. Under basic contract law, it upgrades from an offer to a contract when it has been signed with no changes and it is communicated back to the offeror or the offeror's agent. That will always, always, always be the criteria for we are under contract. So that's what it defines as the effective date. Due diligence, the buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not necessarily limited to matters described in paragraph 4 below, to decide whether the buyer in the buyer's sole discretion will proceed with or terminate the transaction. So here's where we get into the due diligence fee discussion. I've already explained it to you, but it's nice to hear this language sometimes. Due diligence fee, a negotiated amount, if any, paid by the buyer to the seller with this contract for the buyer's right to terminate the contract for any reason or no reason during the due diligence period. It shall be the property of the seller upon the effective date. I told you, it gets paid to the seller on the effective date. Goes in their bank account on the effective date. And shall be a credit to the buyer at closing. So we're going to get into some closing disclosure items later down the road. And you've got to know that due diligence would show up on the closing disclosure as a seller debit, buyer credit. Because we're taking it back from the seller and giving it to the buyer. Seller debit, buyer credit. The due diligence fee shall be non-refundable except in the event of a material breach of this contract by seller, or if this contract is terminated under paragraph 23B, or is otherwise provided in any addendum hereto. Buyer and seller each expressly waive any right that they may have to deny the right to conduct due diligence or to assert any defense as to the enforceability of this contract based on the absence or alleged insufficiency of any due diligence fee, it being the intent of the parties to create a legally binding contract for the purchase and sale of the property without regard to the existence or amount of any due diligence fee. So let me explain this, folks. While I'm sitting here teaching you due diligence fees and earnest money deposits are extremely common, it is possible for them to be zero. You can negotiate no due diligence fee and no earnest money deposit. However, most sellers probably aren't going to go for that. And the way this could try to confuse you on the test, folks, is you may in your minds think, oh, well, it lacks consideration. No, it doesn't. With no due diligence fee and no earnest money deposit, there very much still is consideration. What is it? There you go. The purchase price. So it still has consideration in the way of the sales price, even if it doesn't have any due diligence fees or earnest money deposits. It is possible for there to be zero. We would still have a contract. Now here's the other really important next level of the due diligence discussion. I told you that there is a date associated with it. It's a little more specific than that even. The period beginning on the effective date and extending through 5 p.m. on whatever date we negotiate. So in the earlier example, I said December 20th. Well, folks, what that really means is your due diligence period runs until 5 o'clock p.m. on that date. And then I introduced this language yesterday. Time being of the essence means There is no wiggle room. The date is the date is the date. The time is the time is the time. What this means, if you terminate at 4:59 p.m. on December 20th as the buyer, you're entitled to get your your earnest money back. If you terminate at 5:01 p.m. on December 20th as the buyer, you have forfeit your earnest money. It is that finite. No wiggle room. If you are after 5 o'clock, you are outside of your due diligence period. And before you ask, because everybody loves to ask a squirrely question, it is North Carolina time zone. Doesn't count if you're like vacationing in California or anything like that. I know, one of you is thinking it. Let me go ahead and just squash that. Bree says, will there still be a DD period if there's no DD fee? Arguably, if you negotiated a period of time and the seller accepted the contract with a period but no fee, sure, maybe. So your due diligence period per this 2T runs through 5 o'clock p.m. on whatever date we negotiate. Time is of the essence. No wiggle room. Now, settlement, folks, we kind of talked about, we've talked about this a little bit in earlier discussions on like transfer of titles and closing and recordation of the deed and things like that. Just the reminder, clarity, settlement is, Bill, we're not going down that rabbit hole either. Just don't get that close and we'll be okay. We're not based on who's watch. I don't know. The imperial clock. I got nothing. Settlement is the meeting where all parties go to sign the documents. Okay, that's how you should think of the term settlement. And then closing should really be thought of as recordation of the deed. Now, on this document, it says there's like 4 steps to closing, including the settlement, the satisfactory title update, the recording of the new one, all these different things. But think of closing as recordation of the deed. It's not considered closed until the deed has been recorded in the name of the new buyer. And we don't get paid until then either, right? That's when it's considered to be done. Now, I don't think this is really going to be testable on this, but we've talked about special assessments earlier. And what did I teach about special assessments thus far? There's really 2 things that I want you to know about special assessments. What were they?
Additional tax.
Say it again.
Additional tax.
It isn't additional.
Government fee something.
Yeah.
Isn't it distributed by the people that get to benefit from it?
Yes, that is true. So let's combine that with what Bree said. Special assessments, we talked about that certain taxing authorities have the ability to impose special assessments because, as was that Tara? Are you the one that just said that? Yeah. They gave you a benefit and they say, okay, we did this for you. You pay for it, right? And we said things like sewer systems or sidewalks or things like that. They could impose special assessments. And of course, the other thing was that they are a higher priority lien versus all other liens on the property or all other specific liens except for real property taxes, right? Those are the highest 2. They beat out everything else no matter when they were recorded. For the sake of the contract, the reason they come up is all confirmed special assessments are the responsibility of the seller to pay. They have to pay off the special assessments that are in place as part of the contract. Any proposed special assessments, the buyer is taking title to the property subject to those. If they've not actually happened yet, those are going to be the buyer's problems. That's what it really says. Of course, the fixtures and exclusions, it looks exactly like it did on the listing agreement. However, this is where it really, really matters because this is the agreement between the buyer and the seller. And so any personal property that the buyer wants, they need to make sure it gets put on the contract as it's going to convey. Remember the parole evidence rule. Only what's in the contract is part of the contract. Same thing with exclusions. And if there's something that we want to exclude, it needs to be put in the contract. Otherwise, it's expected to stay in the home. right? Remember the terms severance and annexation when we're talking about something becoming part of the real property versus being removed and turning back into personal property. And so the only time we need to talk about personal property on the contract is if we wanted to do the opposite, which is stay, right? It's supposed to leave with the seller, but if we want it to stay, we need to mention it and ask for it right here as personal property that will convey. And then the only time we need to mention these fixtures, because they're already named here in the contract, the only time we would need to specifically name anything above and beyond this is if we wanted to do the opposite, meaning leave with the seller instead of staying. And so you would put it in here as an exclusion that it is not going to stay. It's not going to convey. Now, this section talks about the due diligence period, okay, and what you may want to consider doing as part of your due diligence. Of course, making sure that you can get your loan. There is no, this is very important, there is no contingency automatically in any contract. So if you ever get a test question that says somebody's under contract using the standard form 2T and they lose their job and they can no longer get their loan and they have to terminate, they're screwed. They're going to lose their due diligence and or earnest money depending on when it happens. There is no contingency built into this contract. And so even if they can't get their loan, it still doesn't save them. They're still screwed. So no contingency. So you want to make sure that you can get your loan as part of your due diligence process to make sure you're comfortable that you're going to get it. You want to investigate the property, home inspections, pest inspections, septic, well, whatever we think is necessary to make sure that there's no issues or detriments to the property. A review of documents. Now, folks, in the real world, I teach that it'd be very stupid to wait until your due diligence period to review things like restrictive covenants, because they're very easy to look up and they could be very problematic for people if you don't look them up beforehand. But it is something to confirm. Of course, making sure that you can get insurance. Remember, we talked about clue reports in the insurance section, comprehensive loss and underwriting exchange. I think there's actually more insurance section later that we'll get into it in more detail. So maybe it was just a brief mention earlier. When we're dealing with people have clue reports on them. So do real property, real estate, homes. And so you want to make sure that you can get insurance on the house, because if it's had a lot of claims, it may be uninsurable or it may not be affordable insurance. Making sure that your appraisal comes back good. We'll talk about that a little bit more in the financing section. Getting a survey to check out the property boundaries, any encroachments, easements, things of that nature. Checking the zoning, governmental regulations. Is it being used for the legal use? Is it subject to any flood hazards? Can you get electric? Can you get water? Can you get internet? Are the streets public or private? All of these things are potentially things we want to find out during our due diligence period. I'm not going to focus on this one because there's another place for it to come up. Folks, this is a very important piece, and this kind of goes back to what we were talking about with the due diligence period or the due diligence process. Because as I'm sitting here telling you, you may find things wrong with a home. It happens all the time. Some things are not so bad. Some things are pretty bad. Understand that this contract states that the home is being sold in its current condition. There is no obligation of the seller to fix anything. So what it says, buyer acknowledges and understands the following. Unless the parties agree otherwise, the property is being sold in its current condition. Seller may, but is not required to, engage in negotiations for repairs / improvements to the property. So if we have an inspection, if we find things wrong, we could potentially attempt to negotiate with the seller to fix it, pay for it, or whatever. But they're not legally obligated to. This is just part of negotiations. Of course, it also states here, buyer is advised to make any repair / improvement request in sufficient time to allow negotiations to be concluded prior to the expiration of the due diligence period. Any agreement that the parties may reach with respect to repairs and improvements is an addition to this contract and must be in writing and signed by the parties. Folks, understand, and I don't know that this is kind of advanced for a pre-licensing class, but you would be advised to try to negotiate any repairs during your due diligence period. Could you negotiate repairs after your due diligence period ended? Yes, but notice the problem, folks. If we go back to the examples that I've given, where you had $1,000 in due diligence money, and $5,000 in earnest money in a due diligence period of the 20th. If you find issues with a home, let's say $4,000 of work need to be done, and you go and you ask the seller on December 19th, still within your due diligence period, and you say, I want you to fix these things or I'm going to walk away. There's a chance the seller might believe you. And now, if you walk away, they got to go back in the market, and there's this automatic stigma because the deal fell through. And then on top of that, the agent would have to disclose the defects that they now know as material facts. And so you could potentially leverage the negotiation to get those repairs. But if you try to negotiate $4,000 worth of repairs on December 22nd, you're outside of your due diligence period. And if you walk away, you're losing $6,000, so the seller may not believe you as much anymore, because losing $6,000 is worse than losing $4,000 and still not getting a house. So can you negotiate after the due diligence period has ended? Yeah, but you've lost your leverage because now the earnest money's on the line. We've already talked about this, but this just reiterates buyer's right to terminate. Provided the buyer has delivered any agreed upon due diligence fee, buyer has the right to terminate this contract for any reason or no reason by delivering to the seller written notice of the termination during the due diligence period or any agreed upon written extension of the due diligence period, time being of the essence yet again. If the buyer delivers a termination notice, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. Bree says, would there be a new contract effective date if you negotiate repairs successfully? No. The contract hasn't changed in that sense. You've just now made an agreement that the seller is going to make repairs. But the contract still stands. It's just amending it, if you will. We've made an amendment to it, right? Added something to it after the fact. Now, here's another big thing to understand, folks, and this is where I told you when we talked about partial performance, substantive performance, and things of that nature. If you don't like something and you care enough to fight somebody in court over it, don't close. Because once you close, you're screwed. It says, closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. If you close, you're saying, okay, we're good. Because now you've got a discharge contract. You accepted it. This section talks about how the buyer is going to purchase the home. Are they going to pay cash? Are they going to get a loan? These are some of the required things that have to be in here. Give us information on the loan so the sellers can make good decisions. Is it conventional? Is it FHA, USDA? What type of loan to value ratios are they getting? So on and so forth. This section right here, I don't think you're going to be very tested on this, but let me just clarify a couple things just as a cautionary tale. I'm telling you over and over again, there is no contingency in this contract, which means there's no contingency on getting your loan approval. There's no contingency on interest rates. There's no contingency on having to sell a house. So it does make mention of whether or not you have a house to sell. It's not creating a contingency though. It's just a statement. I do have to sell a house in order to buy your house. What do I mean when I say it's not a contingency? It means that if you get under contract and you can't sell your house and you ergo terminate, you've lost your due diligence money and or earnest money, depending on when you terminate. I told you a contingency should be thought of as like a get out of jail free card. No penalties. This doesn't create a contingency. You're still going to lose due diligence and or earnest money. It's just a statement whether or not you have a house to sell. This is not something I don't think you're going to be tested on either. It talks about, not that part. Well, yeah, I've already talked about that. You're good. This is testable. Okay. And this is where I told you that things are going to come full circle. Remember when we talked about the Residential Property Disclosure Act? Okay. It went hand in hand in the agency section and the doctrine of caveat emptor, because we said sellers have next to no obligation to disclose anything. And the way that we combat that in North Carolina is with the Residential Property Disclosure Act, which says in most transactions, those two disclosures are required, the RPODs and the MOG. And when did we say that the buyer was supposed to get it? What's the deadline for the buyer receiving these disclosures? Who remembers? No, not 3 days. There is 3 days, but that's not the deadline for the buyer getting the disclosures. Yeah, there you go, Ashley. Before they submit an offer, before they submit the offer, the buyer is supposed to get these disclosures before they submit the offer to purchase on the property. And if they don't, there is a potential out that involves the 3 days. And that's where I told you couldn't fully understand or appreciate it because you didn't know exactly how contracts were formed yet at the time that we first taught it. And so notice here that there are 3 options when you're submitting an offer. You're either saying, yes, the buyer received them and we're good, or no, the buyer did not receive them, so we're not good, or this transaction is exempt from them, so there is no reason to give them to them. If they're not exempt, you don't have if they're exempt, you don't have any protections from it, right? There's no special things for you. But if it's not exempt and you didn't get them, certain things come to play. Now, that being said, it's a longer explanation than what I have left. So y'all go take a break. What you got, Beverly?
I think I realized why we weren't submitting DD. Because it was VA financing. And they're like...
No, VA buyers still do DD.
Really?
Mm-hmm.
Okay, maybe I was thinking maybe because they're a special kind of stupid with the VA.
Well, they are a special kind of stupid, but no, even VA buyers submit DD.
Okay.
Yep.
Thank you.
Mm-hmm. But I mean, like I said, it is I'm not going to say newer, but relatively newer concept. So it very well could be. I don't remember the exact time that it came about, but it was right around that time that you were talking. So it probably was that it just wasn't a thing yet at that point.
Well, and I think I misspoke. I think this was more like my son was born in 10, and I think this would have been like 15-ish, but still, yeah.
Yeah, because I got my license in 2016, and it's been a thing since the time I got my license. But, I mean, I remember them saying it was a relatively newer thing when I got my license. So I think it was around, 2010, 2011, somewhere along those lines. But I don't know.
Okay.
Yep. So we're talking about the very specific protections under the North Carolina, right? This is a North Carolina standard form. This is a North Carolina law that is the Residential Property Disclosure Act. And so I told you there's very specific things that happen. And folks, this is absolutely going to be, I know for a fact it's on my test, but I'm guaranteeing that you will most definitely see some stuff on the state licensing exam. And so if the buyer has not received either the MOG or the RPODs when they were required, here's what it says. Buyer has not received a signed copy of the RPOD statement prior to making this offer and shall have the right to terminate or withdraw this contract without penalty, including a refund of any due diligence fee prior to whichever the following events occurs first. 1, the end of the 3rd calendar day following receipt of the disclosure statement. 2, the end of the 3rd calendar day following the effective date. Or 3, upon settlement or occupancy. So let me try to explain this to you now that you understand how offers and contracts work. If you were to send an offer today, November 20th, and you have not received the disclosures, and the seller signs it, dates it with no changes, and communicates it back, you were under contract on the 20th. That's the effective date. And you would have 1, 2, 3 days from the effective date. 21st, 22nd, 23rd. So you'd have until the end of the day on the 23rd where you could terminate the contract and you would be entitled to get your due diligence money back. So there's 4 times that you could potentially get your due diligence money back. There's number 1. Now, to help you understand the whichever occurs first part, not that it's going to be exceptionally testable to differentiate, but imagine, folks, that when you sent the offer on the 20th and the seller gets the offer and they see that you've not received the disclosures and they say, oh crap, you need the disclosures. So they don't accept your offer, but they send you the disclosures on the 20th. Even though you're not under contract, the clock has now started counting because it's the date you receive the disclosures or going under contract without them, the clock would start. So because they can prove that they sent you disclosures on the 20th, it would still start counting. So imagine that your offer is set in the seller's inbox until the 22nd. Then they signed your offer and dated it on the 22nd and then communicated acceptance. Your effective date's the 22nd. But the clock has already been ticking, so you would still only have until the end of the 23rd to terminate and get your due diligence money back. That's why it says whichever occurs first. It's either triggered by going under contract without receiving them or verifiable evidence that you did receive them. The clock would start. And then, of course, the last piece says, if you close on the property, you no longer have the right to back out. If you move into the property, you no longer have the right to back out. What you got, Brooks?
Never mind, you answered it because the way you initially read it seemed like that they could back out even after they occupied it. I'm like, that made no names.
No, or settlement or occupancy would basically invalidate your 3-day window, right? So these are your three options. If one of these things happens is expired, then you don't have this protection anymore. And so let me give you an example of a test question, right? Janet goes under contract on 123 Main Street without receiving the residential property disclosure. Which of the following would be a true statement about Janet's contract? Janet could terminate on day 2 and receive her due diligence and earnest money back. That'd be a true statement because she would have the protections under the Residential Property Disclosure Act. Everybody with me? So it's either or. If you didn't get one or the other, you would have that protection if they were required. And remember, we told you the exemptions for RPODs, the most common: new construction, foreclosures, transfer between co-owners, and lease with option to purchase, or the lessee already occupies the property. New construction is not exempt on the mineral oil and gas rights disclosure. What would be exempt? Commercial properties, because it's a residential property disclosure. This outlines buyer's obligations. We're going to get into this later when we talk about closing a sales transaction. Certain costs are the buyer's problem. Attorney fees for the title search, title insurance, the appraisal, all of those things are going to be buyer costs associated. Recording fees of the new deed. We'll talk about those in a little bit in more detail. This right here is what I thought I was looking at earlier when I said this is not going to be that testable. This is just talking about whether or not the seller has owned the property for more than a year, less than a year, or does not yet own the property. When would they not yet own it? A builder who's buying a lot, maybe, or an estate thing through like probate or something like that. Lead-based paint disclosure. If the property is built prior to 1978, got to add in that lead-based paint disclosure. Of course, is the property subject to any owners associations, dues, restrictive covenants, things of that nature? Bill, I'm not sure I understand the scenario handout for which form?
I was just wondering if there's like a scenario form that you hand out to kind of go over these forms, like you're saying on the test, there'd be different scenarios, just something we could do some drills with on our own.
I gotcha. No, but the sales contract questions and the online material will give you some of the scenarios. Yeah, and same with the midterm and the practice final. You'll deal with some. Yeah. Excuse me. Is the property subject to any leases? Leases are pertinent, right? And so we'll talk about landlord and tenant later. Seller obligations. A couple things that I would consider pretty important. And I'm just telling you, I can look at this and I can tell you whether they're going to ask you questions on it or not, because there's certain things that I just know they're not going to ask you questions on. So I'm still going to tell you some of it just so I don't skip over too much, but they're not going to test you on certain things. Like, for instance, well, I guess it would depend on the context. Let me just talk about these two anyway. Access to the property. This states that at minimum, the seller has to allow the buyer access to the property to conduct their due diligence, verify repairs, and do a final walkthrough. And that does include the seller providing existing and working utilities. So in other words, the seller should not be cutting off the water or electricity before the buyer has had their opportunity to do all these things throughout the transaction. So conduct their due diligence, verify repairs, do a final walkthrough. Removal of seller's property. These are all obligations of the seller. They should remove all their personal property, anything that's not negotiated, any trash, debris. Of course, when we talked about the different types of deeds in earlier section, we told you that the seller has to convey clear title, and they would have to convey title by way of a general warranty deed. That is the default for this one. Are there other deeds that exist? Yes, but if you're using the 2T, the seller has to convey title by way of a general warranty deed. What you got, Brooks?
So going back with the conveyance section D, I believe. Like you gotta clean the house out, like removal of the property. If the seller doesn't remove all their property by the date, by the closing date and execution of the contract, and the deed recordation, what recourse does the buyer have to get reimbursement on costs, if any, associated with the removal of junk, that kind of crap?
Good question. In short, if the seller does not remove their personal property, trash, debris, or otherwise, the seller is in breach of contract. And I'm going to ask you to hang tight because we're going to talk about what remedies are available to the buyer for a seller breach. But arguably, they are in breach whenever that does happen. Now, remember when we talked about substantive performance, you're going to see that there are certain remedies available to them. But, sometimes the lesser of two evils is close on the property and just deal with it. And that's that partial performance where we may close just because there's a bag of trash and it's easier to just take that out versus suing them in court. But they do have options, and we'll get there. What you got, Lena?
Just to clarify, you're noting like the access to the property and removal of the seller's property as things that we need to know, right?
Those are things that I'm not going to say are probably hugely testable. They're just so oddly specific. I'm still mentioning them. But
Okay.
So like if I'm mentioning it, keep it in your mind somewhere because you'll see that I'm skipping over a lot, that there's no way they're testing you on it. So keep it in your mind somewhere, but it's not nearly as testable as some of the due diligence and earnest money discussions that I've been giving you.
I got you. I'm a paper person, so I printed all this off and I'm like following along with a highlighter and making sure that I note stuff. So I was like thinking that you were saying you don't need to know this, but I'm gonna say it anyway. So
That's
clarify.
yeah. What I was saying is it's probably not going to be testable, but I'm going to say it anyway because maybe it is. There are certain things that I know they're not testing you on. Those things are a toss up in my mind.
Got it.
Yeah. That one. I don't think there's. Once again, I don't think they're going to be testing you on this, but let me make an honorable mention here because I just never know. Up at the top, I told you that, they have the place where, is there a mobile home? Is there a septic, offsite septic, boat slip or anything? One of the other things that was added in at the same time that those were added in was a discussion on whether or not the property was in compliance with government things like zoning and ordinances and, things of that nature. And so ultimately, the only reason I'm bringing this up is because this is another one of those 4 times that the buyer could get their due diligence back. So here's how this goes. Let's say that the property had an unpermitted addition. That means it's not technically in compliance with zoning and building codes. And if the seller discloses it and the buyer is okay with it, no harm, no foul. But if the seller doesn't disclose it and the buyer finds out about it, the way that this little provision is written is that the seller either has to fix it or the buyer can terminate and get their due diligence and earnest money back. So, for example, if the buyer is under contract, finds out that a room was unpermitted, the seller can't or won't get it permitted and up to snuff, the buyer can terminate and get their due diligence and earnest money back. It's just a special, newer thing because of the constant times that this was happening in real estate transactions. It's so new that I don't think it's going to be on your test, but just in case. What you got, Brooks?
All right, so I work at a lumber yard, and I used to work at the counter. So this may or may not have actually transpired within the last year. Say somebody builds an unpermitted house.
Mm-hmm.
Is that house able to be sold under North Carolina state law, or would it be immediately condemned?
It's able to be sold, but highly advised against somebody purchasing it, because if it was built without a permit, that means it was never issued a certificate of occupancy, which means that it would have some significant issues with getting insurance and or compliance and future conveyances and financing. There you go, Beverly, and financing. If a lender knows that, they're not going to lend on it either. And so there's no law prohibiting the sale of it, but it is a nightmare, to say the least.
Would that be a material fact that it hasn't been permitted?
It would be, but remember, sellers aren't responsible for material facts, only agents are.
Right, but how would the agent go about finding out the permit? I know there's a permitting process. Are agents able to submit a request to see the permits? Or
Yeah,
is it just
permits are public
so-
record. You could reach out to the permitting department for that city and or county and ask what permits have been pulled on that property. The other telltale sign, Brooks, is if you look at the tax records, there's not going to be a building there. Because if it didn't get permitted, it didn't get submitted to the tax assessor, and ergo, it's going to look like it's just dirt in the tax records, which is going to be another problem in most municipalities. Some, they don't really necessarily do things the right way, but yeah, I mean, it's a big thing. Yeah. What you got, Cheyenne?
So let's say someone puts in an offer on a house and it's accepted, and then the next day, it's released that the house is going to be taken by eminent domain. Is there anything like that you have to do as a broker, or like you just like the seller just fucked?
The seller or the buyer?
Sorry, the buyer. Sorry.
Yeah. This would come back to probably going to need an attorney. So this goes back to what we talked about, the mutual agreement. And let me explain why. That is something that is absolutely a material fact. And of course, sellers are not legally obligated to disclose these things. However, that's probably something that more often would fall into, something that a broker reasonably should have known in some instances. And so because if there was a broker involved and it wasn't disclosed to you, you could go to court and you could argue that the contract lacked mutual agreement, and ergo would be potentially voidable, and you should have no penalties as the buyer, and you should get all your money back. Of course, that's the iffy one, because it'd be the seller that has to give you the money back, and the seller's probably not going to feel like they have to give you the money back, which means you'd be going after the agent for the money because they failed as the real estate professional to disclose it when they legally had an obligation to, and ergo you couldn't make a good decision on the contract. So it's messy, but there might be recourse if you get an attorney involved.
And whose agent does that fall on? Either agent, like the seller's agent and the buyer's agent?
Falls on the seller's agent predominantly, because the seller's agent is responsible for providing accurate information on the property. But of course, it comes down to the reasonableness standard. The question the commission's going to ask, not necessarily the courts, but the commission, if it goes to them, is, is this something this broker reasonably should have known? So it's, it's a slippery slope. Yeah. But that does happen. There's a lot of people selling back when 540s come through Holly Springs because they didn't want to deal with the government, so they were sneakily trying to sell their properties before they were taken by eminent domain, which was very shady. But it was happening. Let me clarify this. If we were to negotiate repairs or improvements in any way, shape, or form, they are expected to be done in a good workmanlike manner prior to closing. There is no obligation that they have to be done before due diligence period ends. Any repairs that we negotiate has to be done in a good workmanlike manner prior to closing. Talks about expenses. Prorations. Folks, remember, we've kind of talked about prorations and the math with them, you know, the 360-day year versus 365 in this class. And the things that are prorated are taxes, rents, and HOA dues. Brooke says, can the buyer dictate the contractor? Yes, they can. They are allowed to put that in a repair request that they want a specific person to do it. And if the seller agrees to it, then they would have to comply. Seller doesn't have to agree, but, you know, you could request it. And if they agree to it, then it forces their hand. So when we're talking about prorations and adjustments, folks, I told you we default to the seller owns the day of closing. That's just the easiest way to think about it. Good, bad, or otherwise, give the seller the day of closing as a default. And that's what it says. Unless otherwise agreed, the following items shall be prorated, with seller responsible for the prorated amounts of any taxes and dues through the date of settlement, and the seller entitled to the amount of prorated rents through the date of settlement, and either adjusted between the parties or paid at settlement. So just give the seller the day of closing. Good, bad, or otherwise, defaults to them. Now, I will warn you again, though. All your math questions on the state licensing exam are on the national portion. And I told you, when you're dealing with math questions, treat them like a hostage situation. Do what the questions tell you to do, and nobody gets hurt. So there may be questions where it says, give the buyer the day of closing. And then you just freaking do it. You know, like, don't overthink it. But the default is the seller gets the day of closing. So prorating taxes on real property, taxes on personal property, rents, and HOA dues. And of course, taxes on real property are annual. Taxes on personal property, typically annual. Rents would be monthly, and HOA dues could be monthly, bi-monthly, quarterly, could be yearly. But all of these are potentially prorated. Now, folks, let me ask the question again. When might we be prorating taxes on personal property in a real estate transaction?
Mobile home.
There you go. Mobile home again. If there's a manufactured home that is still considered personal property, that's being conveyed, personal property tax would be prorated on that. It could potentially be if there was a boat negotiated or car. I mean, in high-end deals, that can happen sometimes. But typically, it's the manufactured home. Now, here is the next really testable pieces of this, okay? I'm giving you some loosey-goosey stuff in between, but here's the next really testable pieces. Do you remember when I told you that you always have to pay attention on the test of whether or not we're asking you about contracts in general, real estate contracts in general, or an exceptionally specific real estate contract? Folks, what we're looking at is an exceptionally specific real estate contract. So let's backtrack here for a second. I told you when dealing with contracts in general, sales contracts in general, what would happen to a sales contract in general if the property that was the subject matter of the contract was to burn to the ground? What did I tell you would happen? Just a caution here, be careful with the word void. I don't necessarily want you to think that word, but it would die. Okay, it would die. Void means was never legally enforceable on either party. And that's just not the case because, you know, that would imply that we never had a contract to begin. We did have a contract. It just now can't be completed through impossibility of performance. And, you know, somebody's going to get their money back or anything like that. The question is, what would happen in a sales contract in general if the property burns to the ground. The subject matter property burns to the ground. It would die through impossibility of performance because the contract stated that seller was going to give house, buyer was going to give money, and that can't be completed anymore. Because if the house burns down, even if it can be rebuilt, it's not being conveyed on time. It's not being conveyed exactly as it was. Everybody with me here? And here's why I caution you on understanding the difference between sales contracts in general and exceptionally specific ones. This is a specific North Carolina contract that we're looking at called the Standard Form 2T. And it has this provision on condition of the property / risk of loss. If the property is not in substantially the same or better condition at closing as on the date of this offer, reasonable wear and tear accepted, buyer may terminate this contract by written notice delivered to seller, and the due diligence fee and earnest money deposit shall be refunded to the buyer. There is number 3 now of times that the buyer would get their due diligence money back. The Residential Property Disclosure Act was 1. Non-compliance with governmental regulations was 2. The property is not in substantially the same or better condition as on the time of the offer. Number 3. It, however, goes on to say, if the property is not in such condition and the buyer does not elect to terminate this contract, buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by seller on account of any damage or destruction to the property. In other words, if you're using this contract and the house burns down, in theory, the buyer can still legally continue and buy the pile of ashes on the dirt and get the insurance money. But this is a very specific contract. Sales contracts in general do die with destruction of the property. But if we're asking about the 2T, they could buy the ashes and the insurance claim. But let's just clarify for everybody. Is a lender going to lend on a pile of ashes and an insurance claim? No. So if you were paying cash, could you complete it as contemplated? Sure. Now, of course, the other piece of this down at the bottom says risk of loss. The risk of loss or damage by fire or other casualty prior to closing shall be upon the seller. Seller is advised not to cancel existing insurance on the property until after conforming recordation of the deed. And so, as a point of clarity here, it is the seller's house up to the time the deed's recorded. And so their insurance is going to be the one that protects it throughout that time. If you ever have a test question that says seller should schedule the insurance to cancel on the day of closing, don't ever pick that answer. You should not cancel the insurance until the deed has recorded, because if the contract or the settlement gets delayed, you now have no insurance on the home. That's not a good idea. They should never schedule their insurance to end on the day of closing. They should cancel it after closing has happened. Beverly says, I believe rental contracts also terminate in this event as well. Yeah, remember, property-specific things typically die with destruction of the property. So leases, property management agreements, and listing agreements all die with destruction of the property. Sales contracts in general die with destruction of the property, but this specific sales contract does not automatically die with destruction of the property. Okay, so that's why you got to be very careful on these test questions. Janet, will the selling amount be the same? I don't know. I mean, the contract is the contract is the contract. I mean, you can't renegotiate anything unless all parties want to renegotiate. So, who knows? Bree says, with general sales contract, is that, you know, here's the thing, Bree. Do not think of due diligence outside of North Carolina. We are the anomalies. Most states do not utilize due diligence style contracts. Earnest money exists in all states, but due diligence does not. So we cannot say that, you know, there is something specific that happens on sales contracts in general in that regard, because due diligence isn't a thing in most contracts, but it is in ours. So definitely a testable piece there.